Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
In a week last week where schools were striking again, the Children's Homes Association warned MPs of a deteriorating crisis in placements for vulnerable children, and the government loses the court battle over Boris Johnson's COVID WhatsApps. We've been taking a look at the inquiry itself. Dennis.
Yes, Helen, indeed we have. So, after key political figures involved in pandemic planning appeared before the COVID-19 inquiry, what did we learn? Here's a briefing on the key points so far. Here are the four main points so far. Point 1. David Cameron and George Osborne, both key figures in the coalition government, deny austerity affected our preparedness for the pandemic. As had been long trailed, Inquiry Chair Baroness Hallett is exploring the impact of austerity on the UK's preparedness for the pandemic, and both David Cameron and George Osborne defended austerity as a political choice that in fact left the country better prepared to tackle a crisis. But research elsewhere found that public spending reductions made it harder to maintain standards in the crisis. Leading commentators also demonstrated that health inequalities were exacerbated by austerity, which then played out during the pandemic. Point 2. The UK prepared for the wrong pandemic, or did it? Another clear line of questioning was on whether the government prepared for the wrong pandemic. On this, there was more agreement. Cameron repeatedly acknowledged that pandemic preparations had focused on influenza and that this had been a serious shortcoming, though he did not go as far as explaining why other forms of virus had received less attention, admitting that it is very hard to answer why that was the case. This theme raised more questions than answers as it emerged that in 2016, Public Health England had undertaken a one-day planning exercise on coronaviruses called Exercise Alice, which made observations about the need to stockpile PPE, look at border control measures, and plan for mass contact tracing. The inquiry will no doubt explore the extent to which Exercise Alice's recommendations were heeded, and if not, why not? Point 3. Questions are being asked about the role of ministers. The role of ministers, and in particular the importance of political attention as a means of getting things done in government, has been in the spotlight. When reflecting on central government's approach to planning for and dealing with major risks, David Cameron was firm that the system works best when the Prime Minister is in the chair, making the decisions. Finally, point 4. There is disagreement about the impact of Brexit. Did Brexit affect pandemic planning? A letter from the Chief Medical Officer, Professor Christopher Whitty, in early 2019 showed that almost 20 work streams on pandemic planning were paused, reduced or stopped because team members and other resources had to be shifted to focus on planning for a no-deal Brexit. Now, the next stage of the inquiry moves on to political governance, and this will take place during the late summer, and we will report further on this.
Now, the Housing Ombudsman has issued its latest call for evidence for their upcoming Spotlight report into communications and relationships, urging the sector to get to grips with the latest social injustices facing the housing sector. It is currently looking for both residents, advice agencies and landlords to take part in some of the surveys in order to enable it to complete a picture of what the social housing sector is grappling with. The investigation will establish 3 areas of best practice: what it means to be vulnerable in social housing and what is an appropriate response by landlords, what effective communication looks like and how this could help service better outcomes, whether there are areas, either service or demographic, where there are repeated patterns of poor service response. The Ombudsman chose the topic after it said that the reoccurrence of the issue in many of our cases, including severe maladministration findings, where landlords fail to fulfil their obligations around human rights, including the Equality Act, or adhere to their vulnerable persons policy. Richard Blakeway, Housing Ombudsman, said, Social landlords have a proud history of tackling social injustice, and this housing crisis speaks to new social injustices in health, equality, and race. It's time for the sector to rise to this challenge. This is a complex and sensitive area, but repeatedly we are seeing landlords not meeting basic obligations. Much of this is about respect and empathy, but it goes far beyond communications. There needs to be a debate to define what being vulnerable means in social housing. This housing crisis is stretching the concept of general needs housing to its limit. Authorities can respond to the survey via the Housing Ombudsman website. Now, Dennis, the issue of remote meeting provision, the sector is not giving up, is it?
Well, it certainly isn't. A new survey provides compelling evidence in favour of remote meetings. We're not surprised by the details, of course. And here's more on this. The overwhelming majority of councils, surveyed by the LGA, want the powers to be able to reintroduce virtual and hybrid technology for statutory council meetings. The LGA claimed that the recruitment and retention of councillors, particularly those balancing career or care commitments, will be hampered if powers are not given to councils to be able to hold statutory meetings in a hybrid manner. 1 in 10 councils surveyed had a councillor who had stepped down in their authority since May 2021 due to the requirement for them to attend council meetings in person. Councils are required to hold certain statutory meetings, such as for planning and full council, in person. However, during the pandemic, councils were temporarily allowed to hold those meetings virtually until May 2021. The LGA warned that without these powers, communities will needlessly lose good councillors and prospective candidates would be put off from standing for election because in-person meetings were creating real barriers to a range of people engaging with local politics. The government launched its call for evidence in March 2021. The following month, the Divisional Court ruled that meetings held by local authorities in England under the Local Government Act 1972 had to take place in person from the 7th of May 2021, when emergency regulations introduced in the early stages of the first lockdown expired. However, the Department for Levelling Up, Housing and Communities has yet to publish the results of the call for evidence and any next steps more than 2 years after it closed. In March this year, Duluc refused a Freedom of Information request from the Association of Democratic Services Officers and LLG in relation to its remote meetings call for evidence on the grounds of the burden it would impose. Both groups had asked for all information received by the government in relation to its call for evidence, including a breakdown of the responses received, the number received, and the content of the responses, together with any documentation the government holds in respect of the analysis of those responses. Now, John Austin, Chair of ADSO, and our own Helen McGrath have said the results of the LGA survey very much supports the ADSO and LLG campaign to allow councils to hold remote meetings if they wish. The evidence and the merits of our case are compelling. And they added, "We therefore call on the Secretary of State to make the necessary legislative change and allow councils to operate in the modern world as the government and Parliament both do successfully." The Department for Levelling Up have so far made no comment.
Indeed, Dennis, and I can confirm that LRG, together with ADSO, have raised a complaint with the Information Commissioner's Office over the government's refusal to release information obtained in the call for evidence and their reliance on the vexatious burden as an exemption. We will, of course, keep you posted on that. Now, debate on the state of local government in England and the case for the reinvigoration of local democracy has been set out by the Local Government Association, who state that the government should consider accelerating work to devolve greater legal and fiscal powers to local government, moving to long-term and sustainable funding arrangements, and enshrining the Charter of Local Self-Governance in UK law. On that basis, that as place leaders, councils have the potential to identify and address the challenges that matter the most to their local communities. However, councils can only achieve the ambitions of its electorate if the relationship between national and local government is reset to allow for much greater local determination. The LGA points out that councils can only thrive when barriers to engagement with the formal representative process are removed. Now, the average turnout for standalone local elections is around 34%, and local election registers are only 83% complete and 89% accurate when last assessed in 2018. Improving registration levels and encouraging citizens to vote at all elections is a first step to reinvigorating local democracy. Whilst the LGA urged the government to take note of the Electoral Commission review of the annual canvass process and completeness of the register, which is due to be published in September 2023. The report also highlights the barriers to good decision-making by people who reflect the range of experiences, background and insight that exist in their communities, on the basis of a restriction to attend council meetings in person, back to lack of remote meeting provision again. This, the LGA points out, as indeed have LLG and ADSO, can deter a range of people, including parents of young children, carers, workers and disabled people, from stepping forward to represent their communities. Government should therefore lower the barriers to participation and legislate to allow councils the flexibility to decide for themselves how they should use virtual meeting technologies. Dennis, what's your last item for us today?
Helen, the Court of Appeal recently heard an appeal against a judgment declaring the government's national disability strategy as unlawful. Now, this case is important because it illustrates a number of points on the legal principles that apply to consultations and asks the question, when does information gathering actually become a consultation? Here's the backstory on this. At the end of last month, the Court of Appeal heard an appeal brought by the government against a High Court judgment which declared its national disability strategy as unlawful. We currently await the Court of Appeal's decision. But what was the decision at first instance, and what were the key arguments? And this concerns the case of the Crown on the application of Binder and others against the Secretary of State for Work and Pensions. The High Court declared the government's national disability strategy was unlawful, upholding the claim that the Secretary of State had chosen to consult with disabled people through the UK Disability Survey, but that she had not provided enough information on the proposed strategy to allow disabled people to meaningfully respond. The government argued that the survey was merely an information-gathering exercise, not a formal consultation, and therefore they did not need to provide such information. The High Court judge ruled that the Secretary of State did conduct a consultation through the survey, which means they had certain legal duties to follow. The court also ruled that the survey was supposed to help shape the strategy, but the information given in the survey made that impossible. In his judgment, Mr. Justice Griffith said, "I agree with the claimants that the multiple choice format and the word limit on free-form responses did not allow for a proper response even to the issues canvassed in the survey. I have concluded," he said, "that the defendant took on a duty to consult which she did not properly discharge, and as a result, the consultation she carried out principally by means of the survey was not lawful." Now, the government has since appealed the judgment, as I mentioned, and the hearing took place at the end of June. And we will report further on this case, as it will be of a special interest to both governance and policy officers. Watch this space.
And finally from me, back to the government's lost court battle over Boris Johnson's WhatsApp messages, which I mentioned at the start of the podcast. Taken from the local government lawyer, this is the news that ministers who fail to maintain a record or destroy a record of conversations conducted on WhatsApp could risk criminal sanctions, the Information Commissioner has told MPs. In an evidence session conducted by the Public Administration and Constitutional Affairs Committee last week, Information Commissioner John Edwards reiterated concerns that the use of private communication channels for government business could result in records being lost. In a response to a question from the committee's chair, William Ragg MP on what the sanctions would be if a minister was found to be discussing government business using disappearing messages, Edwards said, "It is a little perilous for me to speculate on hypotheticals, but there are criminal sanctions for failing to maintain a record or destroying a record." The Cabinet Office guidance requires that if non-corporate communication channels are used for government business, a copy should be forwarded to the official record, and that means that there's an ongoing duty for ministers and others to consciously assess the content of their message. With so much public attention on the use of WhatsApp, it might be a good idea to review your council's policies for the way in which your officers might be utilising WhatsApp due to DPA, GDPR, SARS and FOI obligations, not to mention legal disclosure. Likewise, councillors as data controllers in their own right, as well as official council business, might benefit from strong direction in this area. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 25, available on the LLG website now. So it's goodbye from me.
And from me too.